Good afternoon. My name is Bryan Westcott. I'm presenting on the developments in amicable settlement techniques over the last few years. By way of introduction, I'm chairman of the SAICE, South African Institute of Civil Engineering. I'm chairman of the Alternative Dispute Resolution panel. The South African Institute of Civil Engineering is a learned society that espouses technical excellence and professional ethics in the civil engineering sector. The members are professional civil engineers and technicians who are employed across the full spectrum of organizations, including academic institutions, public and private sector employers, consulting engineers, and construction contractors. I think if that's next slide is are the slides being presented. If I could see the next slide, there we go. And then the next slide, please. In addition to having technical divisions such as structural, water, geotechnical, etc., SAICE has a contractual affairs subcommittee. This subcommittee, amongst other activities, is the custodian of the general conditions of contract suite of construction contract documents. This is one of the 4 forms of general conditions of contract mandated by the CIDB, that's the Construction Industry Development Board, for use on public sector construction projects in South Africa. It's also widely used by private sector employers and covers any form of construction contract. It can be used in other disciplines such as electrical and mechanical as well. We could have a next slide, please. Now, the SAICE Alternative Dispute Resolution panel has a mandate to maintain the SAICE President's list of approved arbitrators, adjudicators, and amicable settlement facilitators, determine the requirements for admitting a person to be included on these lists. It nominates the president of SAICE, is often the nominating authority in forms of contract, and on application, where the parties can't agree on their own arbitrator, adjudicator, whatever, is to ask the president then to nominate a person. In the general conditions, the SAICE GCC document, the president of SAICE is the nominating authority. The panel also produces guidelines and codes of conduct for arbitrators, adjudicators, and amicable settlement facilitators. It promotes training to improve the ADR competence of people on the list, and it promotes ADR. At the moment, it's with a particular emphasis on amicable settlement. This amicable settlement, or mediation as it was called, fell into disuse. It was in the construction industry. People regarded it merely as a fishing expedition to find out what your cards are of your opponent, and as being not effective. On the panel, we're trying to change this, because I think a large amount of this problem was due to the training of the amicable settlement facilitators, and we're endeavoring to improve this. Next slide, please. I'm going to start by going back in history a little bit about civil engineering construction. I must acknowledge the highly informative paper presented by Dr. Martin Barnes, entitled The Extraordinary History of Civil Engineering. I've relied heavily on this paper for my historical details, and I've also drawn from the guidelines to the GCC 2015 and to observation and discussions with my colleagues on both the Contractual Affairs Subcommittee and on the ADR panel. To be sort of over the past 150 odd years, maybe 200 years, the relationship between the employer and the contractor has mutated largely from that of a master and servant to a simple collaboration between specialist contributors. Well, that is what it should be, but we're not quite there yet. There's still some employers still prefer this master and servant type of relationship. This is where the employer would write the contract document, and this is very much weighted in his favor. We're trying to make it, level it out a bit, make it a more fair playing field because the construction industry is rife with disputes all the time. And I think some of it is dependent because of this sort of perceived unfair playing field. Could we have the next slide, please? All right, I suppose that's coming. In prior years, say going back beyond 200 years ago or so, civil engineering construction projects, I must draw the distinction between this and building projects. But the civil engineering projects such as roads, railways, canals, bridges were generally carried out by military engineers. With the advent of the Industrial Revolution in England, it led to a huge mushroom expansion in a number of projects, particularly in the field of transport, from canals to railways, etc. And this was carried out by civilian contractors and engineers as opposed to the military. And that's where the name civil engineers comes from, their abbreviation of civilian. Two of the early doyens of the civil engineering profession were I.K. Brunel and Robert Stevenson, both of whom were engineers in charge of designing and constructing large infrastructure projects in the 1800s. Amongst their things were canals, bridges. It was the advent of the railways, so there were huge railway projects undergo, and they were the engineers in charge, and they would also then control the construction through contractors. The two had vastly different approaches to construction project management. The next slide, please. This is Isambard Brunel. Brunel subscribed to the approach that the architect stroke engineer, in his case, is the lord over everything, who determines exactly how the contractor must work and how much, sometimes from reading his history, it seems if anything, the contractor should be paid. This approach drove his projects towards conflict, dispute, and destruction, leading to extensive claims and cost and time overruns on a significant proportion of his projects. Next slide is Robert Stevenson. He, on the other hand, promoted the effective collaboration approach between the engineers in charge and the contractors. And his projects were far more successful in being completed on time and in budget. So that's sort of a bit of the background. Now we can go to the next slide. The relatively recent developments in South Africa pre-1970. The architect or stroke engineer wrote bespoke contract documents which were heavily weighted in the employer's favor. They set the rules and their word was law. If disputes could not be resolved on site, the matter was referred to court. things have progressed with the development of the standard forms of contract. There were many of them in 1970, and it was only sort of in the 2000s that they were in South Africa reduced to the 4 CID forms. And with the advent of these standard contracts, became more. It was stipulated how disputes should be resolved. The first standardized general conditions of contract that was published by SAICE was in 1972. And it was for use in works of civil engineering projects and published by SAICE. These general conditions, to a certain extent, attempted to level the playing field in a limited degree. They were followed by revisions in 1990, 2004, 2010, and in 2015. In 2018, short forms, simplified forms, and forms of subcontract were published. The Contractual Affairs Subcommittee is currently looking at producing a revised General Conditions of Contract 2022. The revisions look at disputes and conflicts that happened in the past and see how these can be clarified, because often the dispute arises over interpretation of a clause. So it's just each time to try and improve it. All right, next slide. The first form is arbitration. The 1972 General Conditions of Contract introduced arbitration, and under the Arbitration Act 42 of 1965, it's an alternate dispute resolution mechanism to simplify the cumbersome court process. This was aimed at making dispute resolution process simpler and quicker. The arbitrator was intended to be an engineer and a peer of the disputing parties who was familiar with engineering and construction processes. The outcome was intended to be binding and final, thereby putting an end to protracted litigation. Mediation was recognized as a method of dispute resolution, but as I mentioned earlier, it did not gain popularity for various reasons, one of which was the dearth of mediation skills. Next one, please. Next slide. Next, you could have the next slide. The next form was adjudication, which was introduced to, again, speed up the dispute resolution process. Arbitration over time had become more and more cumbersome and complicated, and with lawyers practicing and lawyers know about court cases, so arbitration tended to become more like mini court cases. The adjudication under the CID adjudication procedure of 2000 was introduced as a quick and effective dispute resolution method, which enabled parties to continue with the project. The outcome was binding, but not final. In other words, it could be referred to arbitration or to court if either party was unhappy with the adjudicator's decision. This adjudication is more what Hubert, my colleague, will talk about as being interest-based, where it looks more at the interests of the party. This is the Stevenson approach. If you go back to my earlier historical note, a more collaborative, trying to solve the dispute according to the contract, according to the law, but it's an informal process, less formal. And the only guideline being that the rules of natural justice must be adhered to. But unfortunately, again, over time, adjudication has now become more legalistic and cumbersome. As with arbitration, it is now becoming a rights-based process, or the trend is that way. That's the Brunel type of approach. And a strictly legal approach to dispute resolution in which the winner takes all. As in all legal contexts, this, if you strictly follow the contract and the law, the outcome might not necessarily be in the winner's best interest. The winner might win the dispute, but then that puts an end to the contract and his project doesn't get finished. And so doesn't always reflect the interests of the winning party. The next slide is now we're going on amicable settlement. As I say, it's been around. It was previously always referred to as mediation, and has always been an option. With this amicable settlement, the parties are at liberty at any time to interrupt the formal arbitration or adjudication proceedings to attempt to reach an amicable settlement. Traditional facilitative mediation is only one of the amicable settlement techniques that can be applied. The mediation process can either be facilitative, evaluative, mediation, conciliation, expert determination, independent opinion, executive panel, or neutral determination. The process is owned by the parties. Initially, the facilitator is there to guide the parties and let them decide what approach they want to take. Do they want the facilitator to give an opinion? And it can be made final and binding if the parties agree. So it's entirely up to them, and a skilled facilitator is required to guide the parties into achieving a settlement. So a facilitator should be, in addition to be a trained adjudicator with all the law component, be trained in all these techniques and be competent to advise the parties on the most appropriate approach. Next slide. Now, it's a consensual process. Any party can withdraw at any stage if they feel like it, and they're not bound by the outcome. And the facilitator, look, he is there, he's trained in writing up agreements, so he can draft an agreement which the parties can sign, and then it becomes part of the contractual documents. And amicable settlement takes very much the interest base, the interests of the parties. That's the Stevenson approach. And it falls within the broader confines of contract and common law. I must stress it is not a court step type bargain where you split it 50-50 or anything like that. Doesn't come into it. It's gaining popularity, because now there's a recently introduced High Court Rule 41A. Sorry, if we could have the next slide, where a judge can order the parties to attempt mediation before taking it further. And in South Africa, several of the more progressive employers or public sector like Western Cape and Sanral are exploring these procedures and hopefully being a lot more successful. Sorry, we're missing. Could we just have the next slide? Sorry. The amicable settlement is not always appropriate for all disputes. It's consensual by all parties, and either party may prefer to stick to the rights-based approach. Usually the employer or his agent is the author of the contract document, including special conditions, and in general, these are weighted heavily in the employer's favor. That's the Brunel influence. Employers sometimes even write out common law processes such as the contra preferentum, so that where there's confusion or grey areas in a contract, the contra preferentum is that the ruling goes in the favor of the applicant, not in the defendant. Amicable settlement is appropriate. Sorry, next slide. And it's appropriate when parties want to maintain a cooperative relationship in view to achieving successful completion of the project and maintain their future relationship. Furthermore, a party may not want to take the risk of being the loser in a winner-takes-all or rights-based decision. It's indisputable that in legal confrontations, a party only ever has a 50% chance of winning. Protracted litigation and associated costs can wipe out any potential gain. Contractual documentation used in our public sector procurement is very intricate, and often small, unsophisticated contractors can easily fall foul of the procedural aspects. They are often gonged out without the actual merits of the case being heard through, as you go through time barring. Next slide, please. This time barring is the indiscriminate abuse. It's there for a purpose, time barring, but it's the indiscriminate abuse. Let me stress the word abuse of time barring provisions that causes the problem. Saying it's in the contracts, proponents say so, it's contract is a contract, the contractor must apply. But this is very much a rights-based approach. It does not resolve the dispute or remove the underlying grievance. The mediation and amicable settlement has been regarded in the past as a waste of time, but this is, as I've said earlier, is probably due to lack of skill of the mediators. And to improve this situation, the SAICE ADR panel is requiring persons on our list to have undergone focused training programs, such as mediation courses being offered by SAICE and various other providers. My next slide, my colleague Hubert Thompson, who's coming up now, who has both legal and engineering qualifications, maintains that engineers are bad listeners. We are trained to identify a problem, analyze it, calculate the solution, and produce a specification and a drawing. The deficiency in listening skills is the reason that the panel is insisting that facilitators and the listeners undergo facilitation mediating training. Sorry, next course, and the next one, sorry, and the next one. If we could go to the next one. My closing comment. In my experience, I've frequently found that the primary issue under dispute is only part of the conflict. Through careful discussion, other issues come to surface, and these are the underlying driving force behind the dispute. This is not to mention personal egos that come into play. At the risk of making, I'm sorry to my lawyer, legal friends, making myself very unpopular, I sometimes suspect that some disputes are driven by unscrupulous legal advisors, while only emphasizing the primary legal issues as opposed to amicable settlement efforts. The cynic in me sometimes wonders if their self-interest in prolonging disputes is not at the forefront of their minds. In closing, the final word, the ADR panel will be encouraging drafters of the proposed GCC 2022 in line with High Court Rule 41A to introduce some form of mandatory amicable settlement attempt before a claim can be referred up the chain. Thank you. That brings me to an end. And now my colleague Hubert Thompson will be coming in to take you through his part of the presentation. Hubert, over to you. I think you're on mute. Hubert, I think you're on mute.
Okay, I'm not there. Thank you very much. I just want to select my screen. Lindiwe, are you still there?
Hubert, would you like us to share your screen?
Okay, I'll share it now. Okay, can you share my screen, please, or put the slides on? Thank you very much. So, are you going to, okay, the first slide. Good afternoon, everyone. I'm going to talk a little bit more on the role of amicable settlement and to add to what Bryan has said here. The outcome of my presentation is to understand the role of amicable settlement within the process to resolve construction disputes, especially in the case of your smaller contracts. Amicable settlement is part of the interest-based approach, and Bryan referred to that, and I think it's a concept that we will have to understand, and unfortunately we haven't got enough time to really to understand the concepts interest-based and right-based approach of the whole process, how to resolve construction disputes. However, we're going to concentrate on amicable settlement as part of the interest-based approach, and it addresses really two critical issues, namely, whether monetary relief is due to a contractor if he's entitled to that, but also, it's very important, it allows both parties to the dispute, the contractor and the employer, to take mitigation measures if circumstances are experienced which are not favorable to their interest and the project. It's the interest of both parties as well as the project, and we have to understand that concept also. Next slide, please. How does construction contracts differ from other contracts? Construction contracts, what I call forward contracts. It differs from your typical single exchange transaction contract, like you buy a motor car, or you buy a fridge, or you buy a house, or entire or instantaneous once-off contract. Typical to buy something or to get somebody to do something, and so on. Forward contracts, like a construction contract, it's conducted over a long period of time. With other words, who should carry the risk for unforeseen intervening circumstances? When the parties concluded the contract, it was not clear what, for example, the ground conditions are. And as they carry on with the project, they experience problems that were not foreseen when the contract was concluded. They are sometimes complex, and they even contain ambiguities and contradictions. Next slide. Now, on this slide, you will see Bryan referred to the different CIDB contracts, the GCC, the FIDIX, the JBCC, the NEC, and GCC. But what is important for us to understand from that, on the left-hand side, you will see there's that part of the interest-based approach and part of the right-based approach. Usually, your typical initiation and your preliminary determinative type of procedure, where you get an answer as soon as possible, it allows the parties to deal with the interest of the project, the interest of the parties. And if they can't get a solution for that, then they move over to the right-based approach, typical your court litigation, arbitration, etc. Next slide, please. So your interest-based approach of the process, and I would make use of the word usually, because this whole process is also a chameleon-like type of activity. If you deal, for example, with the bill of quantity issue right in the beginning of a project, you need an answer as soon as possible as far as that is concerned. Because how do you interpret this bill of quantity issue? Because if it is in favor of the contractor, it means the employer must take certain mitigation measures, either change his budget or change the project or change the scope of the work, how it's going to be done in program, because it might be that there was a problem as far as the BOQ are concerned. If it is a termination of the contract, even adjudication, then the parties are not really interested in, the one party is not interested in what is going to happen with the project. He wants his money. So how you're going to deal with matter depends on what, if it's the beginning of the project or the end of the project, the history plays a role, whether it's a bill of quantity issue, whether it's a termination issue. However, your interest base is typical initiation type of procedures like amicable settlement, and your preliminary type of procedures like adjudication. It addresses the interest of both the parties so that they acquire a better understanding of their rights and obligations. They can explore a range of potential win-win solutions. The outcome is usually achieved quickly in a robust and expensive manner. And again, it addresses those two critical issues, whether monetary relief is due to the contractor, and it allows both parties to take mitigation measures if the circumstances are not favorable to their interest and the project. And that is where amicable settlement, together with adjudication, or as Bryan has mentioned it, the Stevenson approach, much more the amicable settlement type of approach, and the Brunel approach, the much more adjudication, trying to move to a right-based type of approach. But combination of the two can help you. Next slide, please. The right-based, as I say, finally determinative types of procedures is really to determine the rights and obligations of the parties and are final and determinative. There is usually a winner and a loser, and the interest of the parties as well as the project cannot really be explored. The rights and obligations might not be in the best interest of the parties, and even the project and the beneficiaries of the project, the community, for example, who's going to benefit from this. The outcome is reached over a lengthy of period and at a great cost. So there must be a move to the interest-based type of approach. And as we say, we discuss here mainly your smaller type of claims here. Your bigger claims, obviously, what they call the dispute adjudication avoidance board type of approaches that some of the contracts are advocating and so on. But still, during that process, still the interest based of both parties as well as the project are addressed. So the principles that we discuss here can also apply in your bigger processes, your bigger projects, as far as the AABs are concerned. Next slide, please. So far as your ideal construction industry process should be, follow an interest-based approach should be followed, which consists of amicable settlement, amicable discussions and settlement. And if it is necessary, it might be that one of the issues are not resolved through amicable settlement, then it refers to adjudication, and thereafter typical accept and reject discussions. If that cannot be resolved in your interest-based approach of the process, then obviously you have to move to a much more thorough process, the right-based approach to deal with the matter, such as court litigation and or arbitration. Next slide, please. So amicable settlement techniques, disputes are resolved in a confidential, private manner, in an informal manner, in a safe environment, usually with a low cost, and it is flexible. To try to find common grounds and uncover the real issues so that the parties can concentrate on that. Appropriate techniques are usually used with a good, suitable facilitator supported by the necessary disciplines of the party. The parties and they alone should decide whether to settle and on what terms. A mutual beneficial solution. The parties should own the settlement. Both parties should make certain concessions during this process. Next slide, please. So you focus on the mind, on the settlement, and look rather at the future than re-examine the past. You should focus on what went wrong and how the consequences should be rectified, and why it went wrong, and why should it be blamed, and who should be blamed for that. The past should only be examined if it is really necessary to look at the future. And it's possible, even in amicable settlement, to deal with other matters than the dispute, provided obvious the parties agree to that. The budget, the fit for use project, impact on other disputes, alterations required, mitigation measures to be taken, relationship within the parties. While if you move to adjudication, arbitration, you can only deal with the actual dispute between the parties, not mitigation measures and so on. But here in amicable settlement, it allows you to go further than the actual dispute to deal with the matter. Next slide, please. Next slide. So typical, there are two approaches as far as amicable settlement are concerned. The one is facilitative. The facilitator does not give an opinion or a judgment. He rather tries to lead the parties towards a resolution and induce a settlement. So it's for the parties to deal with that typical facilitative of nature. It can also be evaluative of nature, where the facilitator is permitted to investigate the matter, and he may even be asked to offer an opinion that is non-binding. Usually the initial part is facilitative of nature, but maintaining flexible in the approach. Next slide. Next slide, please. If I'm still on air, the slides went away, but there's one slide I want to say here, is the last one, when to follow which process. Although in practice the combination is usually followed, the facilitative type of approach will be followed if both parties have a concern on different matters which have given rise to the dispute. For example, you have constructed a works and the contractor claims that he says, but I'm entitled for payment. For example, he works from the documentation, from the drawings, and that showed certain things to be put into the project. But the employer is not satisfied that he said that should not be in the project because, for example, the specification specified something else. So he has a concern that his interest, he hasn't got a fit for use project. So there are two concerns to be addressed. A typical facilitative type of approach should be followed to address this matter. The contractor, he wants payment for the work done. The employer, he wants a fit for use project. If this matter goes to adjudication, you're only going to deal with the payment issue and not the fit for use issue. While in a facilitative type of approach where you can follow amicable settlement, both these concerns of the parties can be addressed and try to get a solution as far as that is concerned. The evaluative type of approach is usually followed not because there is a difference of concerns, but rather the parties want to know who's right and who's wrong, or what went wrong. So they deal with that in the evaluative type of approach. That is the last slide from my side, Lindy. I'm not quite sure whether I'm still on air.
I am as well. Thanks, Hubert. Now, I don't see any questions. Lindiwe, if there's anyone has any questions, I'm sure either Hubert or myself will be pleased to try and answer. Lindiwe, well, Hubert, thanks. I don't see any more chats. Is that there are no questions. So I think that's, thanks, Hubert. We got nothing else. I think that's the end of our presentation. Good night, everybody. Is that...